registration. The time is 4:05 p.m. on Wednesday, December 1, 2021. And I want to note the presence of a quorum with council members Alyssa Silverman and council member Robert White, both my at-large colleagues. We are meeting remotely via Zoom to hold a markup on Bill 24-0096, the Eviction Record Sealing Authority Amendment Act of 2021, renamed which really includes renaming the Eviction Record Sealing Authority and Fairness in Renting Amendment Act of 2021 and incorporates parts of Bill 24-0119, the Eviction Protections and Tenant Screening Amendment Act of 2021, and Bill 24-106, the Fair Tenant Screening Act of 2021. The committee held a hearing on May 20th, 2021 on the Eviction Record Sealing Authority Amendment Act of 2021 and also discussed Bill 24-106, the Fair Tenant Screening Act of 2021. And then on the 25th of May, 2021, the committee held a hearing on Bill 24-119, the Eviction Protections and Tenant Screening Amendment Act. The measure that is before us today combines the important elements of all three bills. At the outset of this markup, I'd like to note that many of the provisions of this bill have been in effect on an emergency and temporary basis since November 2020 under the Fairness in Renting Emergency and Temporary Amendment Acts of 2020 and 2021. The purpose of today's Bill 24-0096, now renamed the Eviction Record Sealing Authority and Fairness in Renting Amendment Act of 2021, is to extend and in some cases expand on a permanent basis those provisions. This legislation is timely as eviction moratoriums that were enacted by the council during COVID-19 public health pandemic began to expire. We can expect the number of eviction cases that file with the court to continue to expand. This bill is necessary now to ensure that as these cases are filed, tenants receive the due process that they are entitled to, and importantly, that we don't create a whole new class of disenfranchised residents who bear a scarlet letter simply because an eviction case was filed against them. Among the provisions of this bill, they are as follows. New written notice requirements for housing providers in non-payment of rent cases. Previously, housing providers were not required to serve written notice upon tenants in non-payment of rent cases. During the public health emergency and in the gradual lifting of the eviction moratorium in non-payment of rent cases, the council required housing providers to serve written notice on tenants, retain photographic evidence of service of notice, and required those notices to contain certain information. This bill will extend many of those provisions on a permanent basis. And second provision, new threshold requirement in non-payment of rent cases. This bill precludes the filing of a complaint for eviction for non-payment of rent in an amount of less than $600. The bill also prohibits housing providers from filing a complaint for eviction if the housing provider does not have a valid rental registration or claim of exemption and current business license. The new bill also addresses a bunch of additional provisions, including the sealing of court records in all eviction cases that do not result in a judgment for possession in favor of the housing provider. The sealing after 3 years of all court eviction records, except under certain limited circumstances. enhance protection against discrimination in housing based on a tenant's source of income, adding the existence of a sealed eviction record as a protected trait under the district's Human Rights Act. The bill that is before us today is the result of a long process that began in Council Period 22 with the introduction by myself and Council Member Mary Shea of the original Eviction Record Sealing Authority Amendment Act of 2018. The committee held a hearing on that bill in 2020 at a time of heightened concern about the impact of COVID-19 public health emergency on tenant welfare and keeping people housed, safe, and stable, and keeping housing providers whole. Since that time, we have been through a lot together. District agencies perform admirably in distributing the federal relief housing assistance funding. We hope there is more to come, in fact, since tenants and housing providers have both been affected. We want to work together to overcome our challenges. We dug deep in the FY22 budget process to find additional funds to house persons experiencing homelessness and to support the DC Housing Authority and housing persons at the extremely low end of the income scale. We approved the mayor's budget request of $400 million for the Housing Production Trust Fund. In my view, we must not come out of the public health emergency without extending this final set of protections for district residents. And I'd like to thank everyone who came out and testified in support of these measures during our hearings and in private conversations. I also would like to thank other members of the council for the input they have provided in making this bill workable and effective. And I especially want to thank my committee colleagues, two of which are with us today, as well as Council Member Che and Chairman Mendelson for their leadership and support in this effort. The council's general counsel has provided the committee with a legal sufficiency determination, and the Office of Chief Financial Officer has indicated that funds are sufficient in FY22 through FY25 budget and financial plan to implement the bill. The council's Office of Racial Equity has offered its own independent analysis that, though generally positive, raises some questions. The bill clearly advances racial equity and fairness. It contains an extensive review of various provisions scored as status quo, while the majority of the provisions were scored as having the potential to improve on the delivery of housing for DC residents at a critical time in our history. The committee has worked very closely with the courts to determine the limits that they could go to implement the bill. In this regard, we must not let perfection be the enemy of progress. This bill does not miss an opportunity. This bill takes advantage of an opportunity to advance fairness and equity. And let me be clear, not to pass this bill would be the missed opportunity. Through our work together on this bill, the committee has already sparked a brave, empathetic, thoughtful, and open-minded conversation, and we will continue it. We welcome the Council's Office of Racial Equity to the conversation. At this time, I'd like to note two minor changes to the committee print that were made after it was circulated yesterday. On page 15, the committee print that you have before you, lines 294 through 295, a new clause has been added. Information contained within a sealed eviction record to the text, and that is information contained within a sealed eviction record. This clause was added to ensure that so-called ghost records of sealed records that are sometimes maintained by private record and credit reporting agencies may not be relied upon by housing providers in housing decisions if they are part of the sealed record. Secondly, on page 5 of the print at line 100, subsection ARA was okay, was modified to read as follows. No tenant shall be evicted from a rental unit unless the housing provider provides documentation to the court at the time of filing a writ of restitution demonstrating that the housing provider has a current business license for rental housing issued pursuant to DC Official Code 47-2828 C1. Unless the court waive the license requirement, the requirements of this subsection shall not apply to complaints involving subtenants. And I just want to note to my colleagues, we also will be looking at adding this language to the Rental Housing Act, as you can imagine, and of course to the Tenants' Bill of Rights. I want to make sure, but for the purpose of getting the language on the table and before our colleagues so that we hopefully can implement this law, we did not want to add any addendums that might have a fiscal impact. I'll just put it that way. So we're trying very hard to get this language through. This clarifying language was added to ensure that housing providers have a current license at the time of evictions, as well as at the time of filing. Enforcing the requirement at both ends of the case will encourage landlords to get and stay licensed, which is the underlying policy goal. So with that, I would like to turn to my colleagues before we proceed with the vote, and I want to invite my colleagues to make any statements that they would like. All right, Councilmember Silverman.
Thank you, and good afternoon to you, Chairperson Bonds, to my colleague, Councilmember White, and members of the public tuning in for this bill. I am very proud to sit here today as we mark up this legislation that, as you very carefully noted, Councilmember Bonds, will make some of the temporary protections from the pandemic permanent and will improve the fairness of our rental market. As the Council's Office on Racial Equity notes in their analysis, eviction records, eviction protections, and fair tenant screening are racial equity issues. And this bill will make progress for the district's renters, which include many of our low-wage workers and low-wage workers of color. And these are the workers who are most likely to get screened out of decent rental housing due to an old eviction filing. And people need second chances, and this bill is certainly going to help with that. I do want to take a moment to thank you, Councilmember Bonds, and your staff for working with my office and my staff on the committee print. So thank you again very much. I'm glad to see that this bill is going to include, and let me highlight a few things that I really think are important here. A permanent and plain language 30-day notice before a non-payment filing, so more tenants can avoid an eviction filing. Transparency about tenant screening processes, so people don't waste their time in application fees. The ability for researchers and journalists to continue providing accountability through limited access to eviction records, even after they have been sealed, and guidance for the Office of Human Rights on how to spot discrimination based on sealed eviction records and source of income. I'm also grateful and want to thank the tenant and landlord attorneys who provided input for this legislation. Thank you very much. We cannot have a functioning rental market and effective legal protections without you and your input. This bill is the beginning rather than the end of improving fairness in the district's rental market. I know this is very important to you, Chairperson Bonds, and I do look forward to working with you and Councilmember White and the other two members of the committee as we continue to make the district's housing market more equitable and fair and accessible to everyone. Thank you so much, Chairperson Bonds. Appreciate your efforts here.
Thank you very much for your feedback. Councilmember Robert White.
Thank you very much, Chairperson Bonds. I want to thank you and your staff for holding a markup on this bill and for all the work that you all have done on it. This bill incorporates, as you said in your comments, 3 introduced bills: the Fair Tenant Screening Act, the Eviction Record Sealing Authority Amendment Act, and the Eviction Protection and Tenant Screening Amendment Act. And I know it was not an easy task to pull these together and move them forward. This bill seeks to curb some of the crushing consequences of eviction and make the process of renting an apartment in the district a little fairer. Though it may not seem like it on its face, at the core of the problems this bill seeks to address is the affordable housing crisis. According to the Joint Center for Housing Studies at Harvard University, 44% of residents in our region are cost burdened by their rent, meaning they spend more than half of their income on rent each month. And sort of this crushing cost of rent means that more and more people are falling behind. The problem is that with just one eviction filing on your record, whether you were actually evicted or not, your chance of renting an apartment of your first choice decreases dramatically, and families with eviction filings are pushed into more substandard units or sometimes homelessness. And so by automatically sealing old eviction records, and in cases where the judgment was not in favor of the landlord, this bill will allow people to move forward from eviction records that had dragged them down for years. The bill also creates new protections to prevent evictions altogether. Housing providers will not be allowed to file for an eviction when the tenant owes only a small amount of rent or when the provider doesn't have a current license for renting. And the bill also makes the apartment search a little bit easier. With such a tight rental market and so many people competing for the same units, the tenant screening process can be expensive and demoralizing for many tenants. So this bill puts new protections in place so that tenants know the fees and deposits they will be asked to pay before they put in an application. A couple questions that I have on the bill, Chairperson Bonds, for you or your staff. I wasn't clear on, there's a provision, line 145, that indicates that records sealed under this bill can be opened if the Superior Court shows a need. And I couldn't think of a case where there would be a burden on the court to show a need to unseal a record. And so I don't know if this is something that came up at the hearing or if there's an example that would indicate what this provision is getting at.
Okay, you want a response now, or you
It
have
can
other
be,
questions?
well, yeah, well, let me give my one other question or
Okay,
concern
great.
to have them both at the same time. This is section H line, so section 4, subsection H, line 292. This is the section that adds sealed eviction records to the list of protected statuses in the Human Rights Act. My concern here is that I don't think the Office of Human Rights was aware, sort of, of this provision or has had time to sort of contend with the impact it would have on their office. The concern I have here is that we have had sort of a lot of stability at OHR over the years. And even with a lot of instability, the council has added several sort of new requirements and protections on them. There are others in two other committees sort of moving issues right now that impact OHR in a time where they're sort of trying to stabilize. And so I don't have a position on it at this point, but I am concerned about whether or not OHR sort of is equipped to manage this. And I don't know if you have an assessment of that.
Okay, Ram, can we get an answer?
Yes,
Section
Councilmember, I
4.
can give you the beginnings of an answer, and if you would like us to go further, we would be happy to, get more detailed responses.
Okay.
The Office of the Chief Financial Officer did reach out to OHR concerning the provisions in this bill. And I think in the FIS, they might not have gone into great detail, but Ms. Fries was satisfied that adding the trait of a sealed eviction record to the list of, traits that you cannot use to discriminate against a person in housing would not add to their workload beyond what they are expecting in any kind of meaningful way. And so she found no fiscal impact. Yes, we are aware that the Office of Human Rights did testify in front of the Government Operations Committee in 2020 in the last council period. And they were very concerned about putting some of the fair tenant screening provisions under the Office of Human Rights, under the Human Rights Act. And so we did basically move those provisions under the Rental Housing Act and not under the Human Rights Act. So if I put those two pieces of information together, we feel confident concluding that the Office of Human Rights does not feel additionally burdened by the provisions in this bill.
Okay. Coincidentally, because they fall under the jurisdiction of my committee, I had a meeting with the director today and asked the director, who's newly in that position, the interim director, and they had some sense of where they were on a previous iteration in 2020, but did not yet have an opportunity to create sort of a position on this one. I would be less concerned if the agency sort of historically didn't have so much turmoil and instability. That's my concern here. So I guess what I would ask, this is obviously a very important bill, Councilmember Bonds. If we could work together between today and first reading just to sort through this, I just want to make sure we don't sort of set anybody up for failure. But if we could work through it, then I would feel better. Is that fair?
Oh yeah, very, very happy to do that. Yeah, most definitely.
Thank you. Well, thank you very much, Councilmember Bonds. And if you or Ram could just check in with me at some point about the Superior Court provision, some clarity on that would help me.
Yes, Councilmember, I'll be happy to follow up with your staff shortly.
Thank you very much.
Yeah,
Thank you, Councilmember.
Yeah, as you can imagine, we had extensive conversations with the courts and went literally as far as it was allowed.
Okay.
It's a separate part of government, our government. And so, you can only push so hard. And because there are some things that I think we could do more of, but I'm not in the judiciary, so I'll just leave it at that.
Yeah.
We're just the legislative branch.
Yeah. And I'm sure I don't have a concern with the overarching kind of goal. I just, as I was reading the bill, didn't know where that would fit in. So I appreciate it.
All right. Thank you. Thank you very much. Thank you both. And so now I'd like to proceed to a vote. I want to move the committee report and print for Bill 24-96 with leave for staff to make any technical changes. Is there a second? For some reason, my staff thinks we need a second, but I'll ask.
I'm happy to second, Chair.
All right, thank you. We're going to go on record doing that. I think that makes
it
more official than ever. I appreciate that sincerely. So maybe we can put in our rules that this is how we will proceed as a committee. So then I must ask, all those in favor, would you signify by the sound of aye?
Aye.
Aye. All right. All right, and none opposed, because I'll ask, any opposed? No, we don't have anyone else with us today. And so therefore I will report that the measure passed unanimously. And this concludes today's opportunity to mark up this bill. The time is now 4:31 p.m. and therefore no other business before this body. We are adjourned. And thank you, everyone, again. Thank you.